Columbia University just signed a $200 million deal with the Trump administration. And no, this is not just a financial settlement. This is the federal government saying, we're going to peek behind the curtain and stay there. And here's why you, as a pre-law student, need to care. Because this is the beginning of a new era in law school admissions. The Secretary of Education literally called this a roadmap for other schools. Translation, Columbia is just the first domino. Others are lining up right behind it. Today, I'm going to walk you through what's actually in the Columbia Agreement, why it matters for law school admissions, and what you should actually do to thrive in this new landscape. So let's walk through what actually happened here and why this isn't just elite school drama that you can ignore. The agreement with Columbia isn't just a financial settlement. It's basically a blueprint for how elite universities and, yes, law schools will be expected to behave moving forward. Think of it like a massive compliance checklist, except with federal oversight, political landmines, and millions of dollars on the line. Here are the 5 big changes that matter for you and a few hidden details people aren't talking about yet. First, Columbia now has to turn over detailed applicant-level admissions data to the U.S. Department of Education. And we're not talking about general trends here. We're talking about spreadsheets that show for every single applicant what their GPA was, what their standardized test scores were, what race or ethnicity they identified as, and whether they were admitted or rejected. That is wild. In the past, law schools could always point to a vague, holistic process and no one could say otherwise because the data wasn't public. You couldn't audit it. But now, Columbia's data will be on file in federal hands every single cycle. And when that kind of data exists, you'd better believe it's going to be used by lawyers, watchdog groups, journalists, and probably the occasional annoyed parent who's convinced their kid got robbed. And this level of transparency changes the incentives inside admissions offices. It's no longer about just making a good class. It's about making a class that looks good on paper and that can stand up to scrutiny because that paper might end up in a congressional hearing. Columbia has also committed to merit-based admissions. Now, on the surface, that sounds like common sense, right? We admit the best people. Okay, but what does best actually mean? And here's the uncomfortable truth. No one defines it. It's not in the agreement. There's no Vouvray. It's like telling a chef to use only the best ingredients and then walking straight out of the kitchen. In practice, merit almost always gets reduced to numbers because those are the easiest things to measure, defend, and explain under pressure. That means your LSAT score and your GPA are no longer merely important. They are the foundation of your entire application. Now, that doesn't mean soft factors don't matter. They do, but only after your numbers get you in the door. And when we work with students, we often explain it like this. The numbers open the door, the stories get you a seat. But if the numbers aren't there, that door may not even budge. Also, and this is subtle, merit-based language makes it harder for schools to admit high-potential, low-scoring applicants. Even if they believe in your story, they would now have to defend it in writing. That leads to risk-averse decisions, which means more reliance on hard stats. And the cycle continues. Now, here's something most people miss. Elite universities love international students. Why? It's simple. They usually don't qualify for U.S. financial aid, which means they are more likely to pay full sticker price. They're like walking tuition deposits with passbooks. And at Columbia, more than 20,000 international students enrolled last year. And that's not just a group of global learners, that is a revenue model. But under the new agreement, Columbia has to reduce its financial reliance on this group. That could mean fewer international admits, stricter visa review processes, proof of financial ability to pay up front, and tighter rules around what international students can say or do on campus. And I'm not making that one up. Now, here's the part that affects you, even if you're a domestic applicant. If schools lose international full-pay students, they've still got to pay the bills. So what do? they shift focus to domestic full payers, wealthy students, students with private scholarships, students whose parents can cut a check for $80,000 without flinching. And suddenly, it's not just about merit anymore, it's about revenue protection. That could mean less money available for need-based aid, a tilt towards applicants who don't need institutional grants, and more waitlist movement for high-need applicants as schools try to balance their budgets. So no, fewer international students doesn't automatically mean more seats. In many cases, it just means the price of admission quietly goes up. Now, the following is getting less attention, but it's actually huge. Columbia agreed to stop considering race, sex, or national origin in faculty hiring. And that lines up with the Supreme Court's decision striking down race-based affirmative action in student admissions. But this move says we are now extending that principle to the entire university. And that matters because it reinforces a growing legal framework. Public or federally funded institutions must operate in race-neutral terms. And if that's the new standard for hiring faculty, you can bet it's going to be the new standard for admitting students too, even at schools that aren't directly under investigation. So the question becomes, how do law schools build a diverse class without triggering lawsuits? Short answer, they pivot to race-neutral proxies, things like first-gen status, zip codes, Pell Grant eligibility, military service, and so on. And in a bit, I'm going to talk more about how you can frame your story within those guardrails. But for now, I'm going to share a bit more about the settlement. And this one's my personal favorite. Columbia now has to let an external monitor onto campus. Every 6 months, that monitor is going to review admissions practices, audit academic programming, and submit compliance reports to both the university and the government. Now, imagine you are an admissions officer. You're not just reading files and selecting candidates. You are preparing for a third-party auditor to come by and ask you why you picked applicant A over applicant B. You can't just say, I had a good feeling. You've got to point to numbers, consistency. You've got to have a documented process. This turns the admissions process into something closer to underwriting. It's no longer about what's exciting. It's about what feels safe. It's no longer gut feeling. It's about having paper trails. And that change is going to affect every elite school that's watching this agreement unfold in real time. Now, let's step back for a second. It's easy to hear Columbia and think, okay, elite school politics, that doesn't apply to me. But that's the wrong mindset because this agreement and the pressure that created it didn't happen in a vacuum. Law schools don't operate independently from this. They're not islands. They are risk-sensitive, PR-conscious, government-funded institutions. And when one of the most visible universities in America changes its entire admissions and hiring structure under federal pressure from the Trump administration, everyone else takes notes. So let's break down how this is going to ripple through the law school admissions world and what that means for you. The most obvious shift is that metrics are king now. For years, admissions had some wiggle room, and sure, numbers mattered, but a personal statement could still shine. It could still make a difference. If you had an interesting background, that could catch someone's eye. A glowing letter from a judge could maybe sway a borderline case. But now, that flexibility is shrinking. Why? Because decisions are being watched, audited, and potentially challenged in court or before Congress. So, what are law schools going to do? They're going to default to what's safe, measurable, and hard to dispute. First and foremost, your LSAT score. Second, your undergraduate GPA. Those are the hard numbers you can point to when someone says, why did you admit this person? Because if you say they had a 175 LSAT and a 3.9 GPA, it's a lot easier than explaining, well, they just seemed like they'd be great in the classroom. So if you are below a school's median LSAT, you're not out of commission, but you are in a much tighter squeeze. You're going to need a very clear, very specific reason for admissions to take the risk. And we have seen this in real time with our students. Sometimes, just a couple points on the LSAT is the difference between being on the waitlist and getting a 6-figure scholarship. And the margin is now super thin. Now, here's where things get nuanced. Holistic admissions, the idea that you are evaluated as a full person, not just a set of numbers, isn't gone entirely, but it's under major stress. Yes, admissions still wants a diverse, interesting, well-rounded class. They still want veterans, single parents, immigrants, and first-gen college students. But now they've got to justify every single decision on paper, not just to the dean, but potentially to an external monitor or a FOIA request. And that kind of pressure changes behavior. It narrows the definition of acceptable risk. It puts a chilling effect on edge cases, and it makes everyone a little more conservative, no pun intended. So what happens? Schools start shifting their definition of holistic to focus on race-neutral, legally defensible markers of adversity like first-gen status, Pell Grant eligibility, single-parent households, rural or under-resourced school districts, military service, full-time employment during undergrad, and caregiving responsibilities. These are still holistic, but they're also legal proof that someone overcame hardship without referencing race or sex, which schools now have to tiptoe around. So, if you're someone with a non-traditional background, this is your lane, but you've got to frame it the right way. Don't just say, I had it tough. Say, here's how I managed college coursework while working 30 hours a week to support my family. Make it tangible, measurable, and aligned with what schools can say publicly. Now, this one's a little sneakier. You might think, if Columbia and others reduce international admissions, that means more seats for domestic students, right? Well, not exactly. You see, the thing is, international students often pay full price. No scholarships, no FAFSA, just raw tuition. So, when you pull them out of the equation, you create a budget hole. Now, how are schools going to fill that hole? One of three ways. First, they could just admit more full-pay domestic students. 2, they could cut financial aid to need-based domestic students. Or third, they could increase their class sizes. But that's still somewhat capped for many schools. Either way, it creates pressure, not on the application process directly, but on the economics behind who gets in. So if you're relying on institutional aid, this could get harder. Schools might start looking for balance. A few more students who don't need financial help, even if they're slightly less impressive on paper. And that has downstream effects because it subtly shifts the weighting of decisions. It makes wealthier applicants a little more attractive, even if no one's going to say that out loud. And that's not personal, it's just math. Now, a lot of schools flirted with test optional policies over the last few years, and some even implemented them. But guess what? When you're being audited, when every admit might be reviewed by a government official or a hostile third party, you don't want missing data. You don't want ambiguity. You want a clean LSAT score on file. So you can expect that over time, test optional policies will quietly fade out, or at the very least, be treated as a distant plan C. If you don't submit an LSAT score now, it's not going to be seen as bold or progressive. It'll just raise questions. They'll be asking, why didn't they submit an LSAT score? What are they trying to hide? How do we justify this admit when the data is incomplete? It's like walking into a job interview without a resume because you wanted your personality to shine through. It's a nice idea, but it's not how the system works. Now, here's the deeper shift that no one's really talking about yet. It's not just that the rules changed, it's that the mindset inside admissions has changed as well. Before, the thinking was, let's build the best class possible. Now it's, let's build the best class possible without triggering any lawsuits, government audits, or media scandals. And that's a totally different job. It makes admissions officers a bit more defensive, cautious, maybe even paranoid. And that defensiveness will show up in how they read your file. So your job as an applicant is to make their life easy. Don't give them any reason to worry. Make your numbers solid. Make your story clear. Make your file internally consistent. Make sure your background is framed in race-neutral, value-driven terms. Think of it like you're applying for a loan. You're not just selling yourself, you are de-risking yourself. Now, the Columbia Agreement is just the formal version of what's already been happening in the background for a while. Admissions offices are under pressure. They're shifting toward caution, metrics, and documentation. That means if you're applying to law school soon, you've got to shift also. Not later, when deadlines are looming, but right now. So let's walk through a step-by-step playbook for how to adapt in this new environment and come out ahead. I've said it before, and I'm going to say it again. Your LSAT score is the single most valuable piece of data in your application because it's objective, it's standardized, and it's really hard for a law school to get in trouble for admitting a student with a great LSAT score. It's the admissions equivalent of showing up with receipts. You don't have to have a perfect 180, but if you're sitting 5 points below your dream school's median and hoping they'll see your potential, that's a risky bet in a system that is allergic to risk. So when we work with students, we don't just aim to get them good enough, we try to get them above median because that's where the leverage kicks in for admissions, for scholarships, and for negotiating power. Your LSAT score is your currency, so stack it, invest in it, and guard it like it pays your tuition because it does. Now here's a test for you. Read your full law school application and ask yourself, if someone who didn't know me, like a lawyer or the Department of Education external monitor, picked this up and reviewed it, would it make sense? Would it tell a clear, coherent story? Would it justify your admission using facts, logic, and impact? Or would it read like a bunch of disjointed pieces duct taped together? This is what I mean by audit ready. It's not about being flashy. It's about being organized, aligned, and defensible. That means your resume matches the narrative in your personal statement. Your letters of rec support what you're already demonstrating. Your GPA context, like, for example, working full-time during undergrad, is explained in a concise, relevant addendum. And you're not hiding any red flags. You're controlling the narrative around them. Everything you submit should serve a purpose. If it's not helping your case, cut it or reframe it. Think like an attorney arguing for your own admission and make the case airtight. Now, let's address the elephant in the room. You cannot check the diversity box anymore and expect that to carry you. But that doesn't mean your story doesn't matter. It just means you've got to translate your identity into values that law schools can defend publicly. That means avoiding vague generalities like, I faced challenges, or I bring a unique perspective. Instead, you want to get specific. For example, I commuted to college 90 minutes each way while working 25 hours a week to support my family. Or I had to translate legal documents for my parents in high school because nobody else could. Those aren't just stories. They are proof of resilience, independence, leadership, and time management. And notice how those are race-neutral values with obvious connection to success in law school. And if you're struggling to frame your background this way, here's a trick. Ask yourself, what would I want admissions to say about me in a faculty meeting if they had to defend my file? That's the version of your story that you need to tell. Now, this one's gonna sting for some people, but in the old days, if your numbers weren't perfect, you could still get lucky with a great personal statement, a compelling backstory, or a passionate rec letter. There was space for intangibles. And now, that margin is shrinking fast. Admissions is no longer encouraged to take a chance or trust their gut. They are encouraged to document decisions, avoid controversy, and make sure everything looks explainable. That means you can't leave anything to interpretation. Don't assume they're going to notice that leadership award buried in your resume. Don't assume they'll be able to infer how hard your classes were. And don't assume they're going to do the emotional math for why your GPA dipped junior year. Spell it out, frame it, and back it up. You are not being modest, you are being strategic. You are not letting your work speak for itself, you are submitting an argument for your admission. If there's a gap, fill it. If there's a weakness, own it and explain it. If there's an asset, highlight it 3 different times. This is not the time for passive hope. This is the time for proactive execution. Now, the Columbia Agreement is just the beginning. Whether your top choice is a T14, a regional school, or somewhere in between, every law school is watching this. They are quietly adjusting and updating their risk tolerance. They are asking, how do we stay out of trouble while still hitting our targets? And when the people reading your file are operating in fear mode, your job is to make them feel safe admitting you. That means strong LSAT, coherent application, adversity framed in race-neutral language, and no guessing games in your story. The game is different now, but the winners are still the ones who prepare the best.